Picture a schoolgirl in a dusty village. It is morning and she is ready for class, books packed, eyes bright with dreams. But she pauses by the school gate. Her period has come and there is no safe space to wash, no pad to use, and no dignity in the dirty, unlit toilet. So she turns back, not because she wants to, but because her body became the reason she stayed behind. That moment is not private, it's political. It mirrors a truth we have ignored. Menstruation is not a private inconvenience, it is a state of injustice. Something in our law just changed that. Does India's Supreme Court now treat period hygiene as part of the right to dignity under Article 21? Let's get straight to it. This is not about pads, toilets, or policies in isolation. This is about what it means to be treated with dignity in a society that has often whispered about menstruation like it's shameful. In late January 2026, the Supreme Court of India made a constitutional declaration that shifts the ground beneath how we think about menstruation and rights. Imagine a constitution that promises the right to life under Article 21. For decades, courts have interpreted that phrase to mean more than just breathing and beating hearts. It includes dignity, health, privacy, and autonomy. But until recently, when you read Article 21, it did not explicitly talk about menstrual hygiene. The Supreme Court has now filled that gap. In a case called Dr. Jaya Thakur versus Government of India, the court held that access to menstrual hygiene and dignified menstrual health is not just a social welfare item. It is part of the right to a dignified life under Article 21 of our Constitution. What does this look like in real life? The bench led by Justices J.B. Paathashaala and R. Mahadevan did not just read words off a page. They looked at the daily reality of millions of girls and women whose education, health, and self worth were silently eroded because basic hygiene facilities were absent. They noted that lack of access to affordable menstrual hygiene products, clean toilets, privacy, and safe disposal spaces does not just hurt bodies, it erodes dignity. And where dignity is eroded, life as promised by Article 21 is hollow. Pause for a second, think about it. The Constitution's promise of life now includes the ability to menstruate with dignity. It is not abstract anymore, it is a constitutional truth spoken from the highest seat of justice. The court also linked this right with equality and education. A girl who is struck at home during her period cannot learn on equal terms with her classmates. The absence of menstrual facilities becomes a barrier to participation in society. It is not merely a taboo, it is discrimination. Let's unpack that. We often say equality means treating everyone the same. But this court reminded us equal treatment is not real equality if the problems people face are different. Equality must account for real differences. So, if two students walk into a classroom but one has no pad and no private washroom, their access to education is already unequal. The court saw this as a breach of the right to education under Article 21A2, tying dignity, education, and bodily autonomy into one thread. This judgment did not happen in a vacuum. The litigation was sparked by a public interest litigation in 2024 that highlighted how lack of menstrual hygiene facilities in schools leads to absenteeism and even dropouts. Family stories emerged, girls missing tests, skipping classes, or abandoning their dreams because of something as natural as menstruation. The court did not just hear legal arguments, it saw the faces behind the numbers and it said dignity is not negotiable. What tilt does this give to India's constitutional landscape? First, it underscores that rights are not static. They evolve with lived realities. Article 21 has long been a dynamic provision, flexible enough to absorb new interpretations that match social progress. Today, menstrual dignity sits under its umbrella alongside privacy, health, and livelihood. Second, this transforms menstrual hygiene from a policy goal into an enforceable right. Governments, including central, state, and local, now have constitutional obligations, not optional targets. Think about that. It is one thing to have a health policy recommending sanitary products in schools. It is another to say the law demands it as part of what life means in India. That is a legal weight no government can duck. Schools have to provide free biodegradable sanitary napkins and functional gender segregated toilets with water and disposable systems. Private schools risk derecognition if they ignore these standards. It is concrete action rooted in constitutional commitment. Now, here is an ethical spark. We must watch implementation. Declarations on paper are meaningful only if they resonate in villages, towns, and classrooms. The spirit of the ruling is clear. Dignity in menstrual health is not a privilege, it is a right. But that dignity must be felt everywhere, not just in big city schools. Real change will mean training teachers, educating communities, creating supply chains for quality products, and dismantling stigma that tells half the population to be silent about their own bodies. What does this mean for the future of rights? This judgment nudges us towards a constitution that sees the lived body, the social body, and the legal body as interconnected. Rights are not solely in text, they are in experience, in access, in participation. Menstrual dignity is now a constitutional promise because the court said no life can be dignified if half of its experience is erased or ignored. And that changes everything. So, here is the lingering thought. If dignity includes menstrual health, what other lived experiences have we pushed outside the frame of constitutional visibility? Where else must the law catch up with life itself?